The Board of Education special meeting for June 21st, 2018. Eric, will you call the roll?
Member Russ.
Here.
Member Dillard.
Here.
Member Milligan.
Here.
I'm here. Member Rinaldi. Here. Okay.
Moving on to item number 3, the approval of the agenda for this afternoon. Is there any additions, corrections, or deletions to the agenda? Hearing none, I will move that we approve the agenda.
Second.
Okay, roll call vote.
Member Russ.
Aye.
Member Dillard.
Aye.
Member Milligan.
Aye.
Member Resnick is aye. Member Rinaldi.
Aye. All right, moving forward, item number 4 this afternoon, the Hall of Fame Village resolution. At this time, we will turn things over to Jeff Popper.
We gotta make the motion first.
I was going to have him explain.
Let's put it on the floor.
Yeah, it has to be on the floor.
Yeah, so I'll move the adoption of the resolution we presented concerning a new, we've,
Do you have the language to read?
yeah, I'll just read the language. Resolution authorizing and approving actions to facilitate a proposed tax increment financing revenue bond issue to finance costs of public infrastructure improvements benefiting the development of Tom Benson Hall of Fame Stadium, Don Scott Field, and Johnson Controls Hall of Fame Village.
There's the motion.
Needs a second.
Second.
Up for discussion.
I'm happy to say we're back with, we still have a deal that's closing on June 27th as planned. Eric, I think you have a copy of this resolution. There's some minor nit type changes, so I'm just passing to the board members. I just gave you one, Adrian, from the, obviously I fixed the date since it's today and not Monday. And then let me also pass around, this is copies of the acknowledgement declarations that I left for you with red lines that show the actual changes. There are no substantive changes since I was here on Monday. It's the two different ones, one for youth fields and one for the stadium property. And I'm happy to, address any questions anytime. Stop me, and or direct me as to what you wish to talk about. I think maybe the way to start is to walk through the resolution. So I tell you what we are doing. That'll sort of highlight why I think what we're doing, is all appropriate and consistent with my directions on this matter. And then we can go through one of the two declarations briefly, at least, to highlight the pieces of it that relate to what we talked about. The two declarations are substantively identical. I mean, there's some small changes because of differences in some of the way the property interests run, but fundamentally they're identical. On the resolution, I sort of identify in the first recital sort of just lays the groundwork in the history on, we've been at this for a while now. You've been adopting resolutions since probably early 2015 on this, actually late 2014. And as recently as March the 12th, as recently as March the 12th this year, we approved the bridge loan. Our participation in the bridge loan, we gave, provided the estoppels that were necessary to allow the bridge lender to take a leasehold mortgage on the Hall of Fame Village interests, and be comfortable doing that. That is, of course, ongoing. At that time, we talked at least briefly about the fact that there was a tax increment financing revenue bond issue coming, and it was a little unclear as to how large it would be. Right now, the actual amount is probably $10,030,000. That amount came down about 11.64 was sort of the anticipated amount. I have both of those identified amounts in here. One is sort of the maximum amount, the other as the estimated amount of the bond issue. Currently, it came down simply because of the where the values came out, because this turns essentially on the value of the property and the value of the incremental value of the property above existing values. The second recital really just lays out the various interests, including the ground leases that we have with the Stark Port, and more importantly to us, the reciprocal easement and covenant agreement that protects your right to use for our kids to use the property and the various properties that are going to be part of Hall of Fame Village. And I recited that in part because one of the key charges for me was to ensure that the REA was protected in a context where the fundamental security for these bonds will be a tax lien securing the service payments in lieu of taxes that sort of take the place of the taxes in a TIF financing, as we discussed the other day. Obviously the properties are then leased for a 40-year period to Hall of Fame Village entities, and the further background on this was that in 2015 we gave sort of a preliminary approval to the idea of doing a tax increment financing on all of these properties, and as part of that we and Plain Local School District, because there are properties in the village, properties in Hall of Fame Village that are in both school districts. Both school districts essentially agreed to allow the tax increment financing to go forward on a mutually agreed basis. They agreed with that with Hall of Fame Village and the city, this is a city tax increment financing project. Somewhat complicated by the fact that most of the property, other than the school property, at least in 2015, was outside of the city of Canton. And so we've sort of got a process, an ongoing process under the compensation agreement and under the TIF ordinance, where as properties are added to and annexed into the city, they have to be added to the tax increment financing, which will then tie into our right to compensation under the compensation agreement. We have, because we own the properties that we lease to through Starkport to Hall of Fame Village, we have applied for the tax exemption under the TIF statute. That has not yet been granted by the state, but there's no reason it will not be. We've applied for it on the stadium. We have signed the application on youth fields. I think that is still being held pending the closing, and then it'll be filed with the county. It'll then go to the state for sort of the state's imprimatur on this tax increment on the tax exemption that lays the groundwork for the payments that's secure the financing for these bonds. Let's see. The Hall of Fame Village essentially has arranged for the financing. I mean, this is ultimately to benefit their development. The costs that can be paid for from a tax increment financing like this are public infrastructure improvements. I mean, it's roads, utilities, things that you might think of as public infrastructure improvements. Ultimately, what can be financed is subject to approval by the city and its council, and by bond council approving the bonds. And that is, I think there are still some final sign-offs on that expected on Monday before they close on Wednesday. But I don't think there's any dispute on. I don't have it with me actually, but there is a packet of sort of the improvements they expect to finance. But it's, Harrison Road improvements and some utility work, some stormwater issues, resolving things that fit sort of the concept of public infrastructure. The buyer of the bonds is Cuyahoga River Capital, which is a fund that specializes in economic development in Ohio, mostly Ohio, economic development bond issues. They buy them directly to hold, and so one of the nice things about this is that these bonds will not be in the public, sort of with disclosure obligations, continuing obligations. Not on us, but on anybody involved in the process. They will go directly to a buyer who will buy those bonds and hold them. He will advise everybody that he knows what he's buying, and that's designed to protect essentially all the participants in the transaction. As a condition to buying the bonds, he required that we file a declaration against our property that essentially acknowledged some of the obligations that were being attached to the property. This is a property-based financing. The key point of departure, and one of the things that we have spent many months working through, is would the bond payments be attached to our property as opposed to the tax payments? So the tax payments, they're attached to our property as we sit here today. If the taxes are exempted with the resulting obligation to pay service payments, they will be collected in the same manner at the same times and by the county in the same way that taxes are collected, and they carry the same tax lien. And so no argument, I don't think we've ever had any argument that somebody has to pay the taxes, and the taxes are protected by a lien. Where the argument has been is, are there, payments that are really bond payments, which could arise if, for example, the value of the stadium was reduced. If the value of the stadium is reduced by the auditor, there would not be enough payments in lieu of taxes. The pilots would not be enough of those payments to pay the bonds. Somebody else has to step up and pay those. And our position has been, and it has now been fully sustained, that that is a Hall of Fame Village issue, not a school district issue, not a public issue. And the real conundrum was, I think, for the buyer in Hall of Fame Village, was they were of the view that you couldn't have a tax lien you couldn't have a true lien securing those payments unless they were really attached to our property. There is an obligation for those payments. It's Hall of Fame Village and the owners of the lessees. We said that's fine. We don't know whether you can or not, but you can't have a tax lien securing against our property, securing your bond payments. And so that's where we ended up finally about 10 days ago. They essentially agreed to that position. The declarations that you have in front of you, we spent most of last week sort of fine-tuning them. And they acknowledge that service payments will need to be paid. And if they're not paid, there is a tax lien. At the end of the day, the tax lien is something that is foreclosable by the county treasurer in consultation with the county prosecutor. And we have not, arguably somebody can go, the trustee or a bondholder can ask the county to enforce it, and presumably they'll listen. But I think nothing can happen without the county acting. And if they act in a way that tends to foreclose a tax lien, we will have notice because it will relate to our property. And at that point, we will need to address the issue. If not before, if we know about it in advance, we'll address it in advance. There are some elements of the structure that we have insisted on that will allow you to know in advance if there's an issue. one of...
The issue could potentially be that Hall of Fame Village runs out of money.
Stop paying taxes.
Okay.
Yeah, they are going to be required to escrow with the trustee on a monthly basis for all of the taxes and service payments and minimum payments that are required. So, you know, and we are required to get notice from the trustee if there's ever a failed payment on a monthly basis. You know, payments on the bonds occur every 6 months. Payments of taxes essentially occur every 6 months. And they've designed the structure so that, you know, there's 6 months of escrowing funds. That money then is used by the trustee to pay the taxes to the county. The county then distributes the money to the city and it gets to the trustee again. It flows around, but we will know in the first part of the cycle if there's a failure to pay, and we will have the right to step in then and essentially cure anything related to the bonds, and then exercise our rights under the ground lease, because any eventuality like that would result in a default under the documents we have that ultimately flow through to the Hall of Fame Village.
So this is I looked at this. This has till 2056. That's 40 years. The TIF is 30 years.
There are a number of dates that are in here that are relevant. The 2114 is that's when our ground lease runs out. So it's a 96 years left on our ground lease. The Hall of Fame Village leases run through 2056. The TIF will end in 2047, collection 2048. So potentially then these dates also offer an opportunity to cure if there's something wrong, because these can be renegotiated. Sure. Sure. One assumes that we won't be, presumably we won't be renegotiating with them. The most likely scenario is that, as long as there's a bridge loan, as long as there's a lender to Hall of Fame Village, they're going to need to cure in order to protect their interest. We've talked a little bit about this in the past, but the bridge lender has a mortgage on the leasehold. It's on the Hall of Fame Village leasehold. And if there's a default under the ground, the reason we needed to do the ground lease estoppel for them to do the bridge loan was to essentially tell the lender, as we sit here today, unless we've identified them to you, there's no defaults under the ground lease, because otherwise they wouldn't have been able to enter the loan, because if there's a default under the ground lease, if we terminate the ground lease, the bridge lender to a sublessee gets nothing. They just have, that's not quite true. They have a right to come to us then and ask if they can get a new ground lease from us, and if they're willing to essentially cure all the defaults, then we have an obligation to give them one, as long as they cure everything. But that's the only thing they have left if we terminate the ground lease that sits above them. So, what else? That sort of describes sort of how we get to the conclusions that are built into, I think, the final whereas, which is at the bottom of page 3, which essentially says, and I'll just go through them, whereas this board has determined that the declarations will not impose any additional burdens on the interests of the school district in the stadium property or Scott Field property. I think that's true. That the declarations contain provisions to protect the rights and interests of the school district under the REA and use agreement and under the compensation agreement. That the issuance of the initial TIF bonds will enable the school district to receive and maximize the benefits under the compensation agreement, including the compensation payments payable to the school district, including with respect to the ground lease properties, and is otherwise in the best interest of the school district. And, basically determined that moving forward will support the purposes of the project that we decided on in 2014 and 2015 in terms of, I recite back to the educational purposes, the purposes that you entered into this to enhance the educational experience of your students as sort of identified back in 2015 when we signed up for this in the first place. The connection here is that without the TIF bonds getting done, the bridge loan will probably wither. There's, what happens next would be up in the air completely if the TIF bonds don't get done now. That's the truth.
Can you, because the public is present at this meeting, can you address, mostly for the benefit of people who don't know, what the relationship between Plain Local School District and Kansas City School District is in this?
Yes. Plain Local School District does not have, there are many properties in Hall of Fame Village, as it is expected to be developed, that lie in Plain Local School District, probably most of the property. At the end of the day, will be in Plain Local School District as long as the, if the village develops out as anticipated. The initial properties that sort of make up the core of what has happened so far all are not only within Canton City School District, but belong to Canton City School District. In 2015, both school districts have a right to notice and compensation as a condition to approving or permitting a tax increment financing like this to go forward to permit the city to exempt property for this purpose. That's what we addressed in 2015. It was the right of both school districts to receive compensation sort of in lieu of the taxes they would otherwise have received if the property got built and it was taxed in the ordinary course. The reason you would do that is because if you didn't do that, in all likelihood, the project wouldn't have moved forward. So it's you take a portion of what you would have gotten, from the taxes as consideration for agreeing to let this go forward, so they get the benefit of the TIF to cover some of the infrastructure costs that need to be paid. The real distinction between the districts, and the reason that Plain Local is only on this in a very limited sense, is that what we're dealing with right now is property that belongs to the school district. And there's these two properties that we're dealing with right now, and then the parking to the west of the McKinley. That will, at some point there will be another request to TIF that property. It's part of the tax increment financing district, if you will, but there's nothing on it yet, so it hasn't been redeveloped, and so there's no point in putting trying to finance off of it at this point. I have in your resolution, I have put, in my view, enough authority to essentially authorize another declaration in this form as it relates to the parking when and if that becomes an issue. But right now, that'll be the last time when the school district will have its property sort of in play. The one other thing that we did do, and both districts have different issues and different interests in this project, and they took somewhat different positions back in 2015. I mean, one of the things that's in the school compensation agreement for Plain that wouldn't have made sense for us is that there is real protection from Hall of Fame Village for the base value. I mean, one of the, they have a lot of houses out there, most of which I presume are now gone. And so when that gets reassessed without any improvements on, the value goes down, presumably. And so there's protection for base value for Plain Local that we don't have if you get deep enough inside the compensation agreement. One of our issues was concern over what happens if properties are built across property lines. Because I am presuming, I'm not certain I know this, but I'm presuming that their tax rate may be lower than ours, I don't know. But if you were building something across property lines where there's property in Canton Schools District and property in Plain District.
Would that be more incorporated limits, more, because you can't build across property lines. You've got to either replat.
I didn't say it right, Jay.
No, that's okay, because trust me, I deal with this every day.
But yeah, no, across district lines.
Yeah.
Across district lines. It would have to be inside of Canton in order to be part of the TIF, but it would be across the 2 school district lines. And we have the 5 acres of land up north of the stadium that they now own. That is part of the Kansas City Schools, and the Performance Center and some other things I think are going to be, perhaps in part across that line, perhaps in part across the parking lot. I don't know exactly where those lines are right now, but one of our concerns was making sure they couldn't game the system. I'll use that term, it's by putting the building within one district or another. So we put an agreement into the compensation agreement that all building value gets divided 50-50, for tax purposes.
So all they would do is geographically start shifting
Right.
where's what.
Yeah, so we have, the land is wherever it is, but the building value gets split 50-50, and that sort of was another one of the, so there's a lot of things like that that are built into the relationship with Plain Local and Canton Schools. They have agreed, the one thing they've agreed to in here is something we have agreed to, which is to a covenant not to challenge, to try to reduce the value of the property below a certain level, generally reflective of what the auditor has determined it is. So.
And actually, property values up in that area now have increased very dramatically. So some of that provision really is there to safeguard them, but the reality of it is a lot of those properties now are, with a lot of properties in Canton in general, too, the values are up.
So with this declaration, this is another layer of protection for the Kansas City School District with regard to, especially with regard to if Hall of Fame Village does not perform, does not go as well as intended. This protects us and protects our financial interest in those properties to the best extent possible.
To the best extent possible, absolutely. And I think we can go through a little bit, but one of the things we did, maybe it's time we just sort of leaf through one of them. I'm going to ignore the recitals, which go on for almost 4 pages, and we can talk about what's actually in the substance of the document. I think I'm on the stadium. I'm on the stadium declaration. So, starting at the bottom of page 4, I think we actually have something where these are the things that we are saying are attached to our ground, and the first section essentially says that we agree that there is an obligation to pay the service payments. These are the in lieu of tax payments, and that they're in Part B says same amounts as the real property taxes that would have been charged and payable at the same times, subject to the same late charges and such. Everything is exactly the same. And then C references 5709.91, which is the statutory provision that extends the tax lien to a service payment obligation like this, and says it's subject to the same lien rights. Part 2, heavily bargained for. Recognition and survival of the REA and use agreement. Basically has each of the declarants on behalf of the burden parties. The burden parties are anybody who owns that property, anybody who is part of the property, whether it's Hall of Fame Village or us or and each of the benefited parties, and this is the key part, each of the benefited parties, it's the bondholder, the trustee, the city, the issuer of the bonds, the county officials who are charged with enforcing tax liens and such, they are all charged with, under this agreement, under this statement that will be recorded, knowledge of and recognition that the REA and use agreement survives, and it is intended to survive. It is reflective of language in the statutorily referenced provision there, 572119F2, protects easements and covenants of record running with the land. And so Part A essentially says that, those rights are all protected under that statute.
So it can survive a bankruptcy.
Yeah, survives everything. Survives foreclosures, survives leasehold foreclosures, it sticks to the property. In Part B, we recognize, acknowledge, and agree that it binds the property interest therein, and notwithstanding the lien or any lien foreclosure, it survives. Part C then goes one step further and says, even if we're wrong, even if somebody asserts that somehow that is incorrect, and is able to sustain that position, that a lien foreclosure, a tax lien foreclosure trumps that, then under the terms of this declaration, all of those covenants are incorporated by reference into this declaration as part of this agreement, and therefore survive. Right? So they, even if we're wrong and they don't survive a tax lien foreclosure, they're essentially reinstated under the terms of the document under which you foreclosed. And then they survive for the next 99 years or whatever. So that's what Part C is about in 2. Section 3 is a sort of a bow towards the compensation agreement. There are provisions in there that are stated to run with the land, but the document is not attached to the land yet. And this is to attach those covenants, including the 50-50 agreement on value, to the property. Part 4 talks about the ground lease and the project lease, and the fact it acknowledges that if there is it talks about a new ground lease. Essentially, we are acknowledging that there are other interests that exist out there, and we agree that, for example, that we will treat somebody who forecloses under this document as essentially as if they foreclose under the document and they take the leasehold interests, we'll recognize them as holding the leasehold interests, and we'll provide the benefits that they're entitled to under our ground lease. Part B, ground lease termination and merger of title, that is a provision that is intended to give us the right on a termination of the ground lease to redeem the bonds. And that's important for us in terms of any kind of an exit strategy. So if for whatever reasons there are defaults under the ground lease and people stop paying, we want to be in a position to essentially extricate ourselves. We terminate the ground lease. We essentially inherit the obligations that, well, we have the right then to essentially redeem the bonds and eliminate the TIF, which would be in all likelihood in our interest, because once the TIF is eliminated, we can then go back and reclaim the governmental property exemption so that we're not paying tax and then using only a piece of those to pay for bonds. So, in all likelihood, you would want to refinance in some fashion at that point, figure that out. Section 5, minimum value. We have a covenant that we will not challenge the value. This will be a common theme on all of these. We will probably be asked, like Plain has been asked to agree on these properties, we'll probably be asked to do the same thing on each of the properties as they are TIF'd, whether we own them or not. Because we as a school district have the right to challenge any value in the county, just like Plain Local does. And so that's the So there will likely be some sort of a minimum value covenant on, throughout the village. At the end of the day, our interest will be in a higher value, not a lower value. So, certainly on anything where we're not the owner. Refunding and additional bonds. We have some limits. In order to make sure that we have some control over our exit strategy, we put limitations on their ability to issue additional bonds under their structure, additional bonds that would be secured by our property. And that's just sort of outlined in ways that are intended to, my personal belief, I've been told this by CRC, that, in all likelihood, nobody will be able to issue any additional bonds on this property for 10 years or so because of the way the bonds are structured, not on this property. We'll be issuing lots of bonds on other properties, but not against this property. And so, but we wanted to make sure that we have limits.
But what happens after that 10-year period, if they do?
And they're still subject to these limits, right? So we have limits on how much coverage they have to have. So it's got to have a relationship to the value. It's got to have, there's some protections in terms of how they sell it, those sorts of
They
things.
can't throw these terms out just
No.
because they want more. Okay.
No, these terms are going to be attached to the ground. So obligations unconditional is just, that is boilerplate, but it just means that there's no right to offset whatever obligations are under this. That's fine. Provision of information. We'll cooperate with the city has reporting obligations on any TIF. We need, at the end of the day, it's a Hall of Fame Village obligation. They're going to need to cooperate, but they may want us to cooperate in some ways. And all owners are bound to essentially cooperate in giving the city what it needs to do. Use of the property, basically, there's some prohibited uses under the TIF statute, and so that's now attached to our property. We can't put up single-family homes on the stadium site, and we've agreed not to do that. Covenants run with the land. These are in-rem obligations in the sense that they're not personal obligations of the school district. They are obligations, the taxes are obligations that attach to the land. And we, go to some lengths later on to say that the school district has no personal obligations with respect to those. Obviously, if we need to protect our interest in the land, it may behoove us to appropriate money to pay the taxes or to sort of cure defaults for some period of time while we figure out what it is that you wish to do. But you have no personal obligations and you're expressly exculpated from those under this declaration. And that's where the rest of it is, as I say, the rest of it's largely sort of general provisions that don't actually add very much. You can talk about anything you want, but I don't think there's anything there that is of interest particularly. Enforcement in section 10, it just talks about the lien, and it says both the Stark County Treasurer and to the extent authorized by law, a bond trustee are hereby authorized to enforce the lien. Bottom line is the lien can only be enforced in accordance with law, and that is, as we sit here today, by the county treasurer with the county prosecutor, essentially filing a foreclosure action against the property, and you would be the notice party because your name is on the county records as the owner. The joinder is important. The joinder is about 4 pages back further. There's a joinder of the project lessee, that is Hall of Fame Village Stadium in this case, and the developer, which is Hall of Fame Village, the parent. They are joining all of the obligations and agreeing to indemnify you for the failure to conform. And so that's what that is. And then there's a minimum value covenant from Plain Local, which we talked about. Any questions?
Appreciate your work.
Last thing I would say is just take 30 seconds to, because that's all it will take me, on the resolution. It is, the sections 1, 2, and 3 are sort of the standard approach, which essentially incorporates the recitals as a statement of the basis upon which we're acting, and as the public a statement of purposes for which we're acting. And it approves the declarations in the Form 1 file. Section 2 authorizes the requisite officials to sign, and Section 3 authorizes board and school district officials to do the other things that might be necessary. There may be a couple of consents we have to sign relating to, like, the cooperative agreement, something such, but nothing of any material significance. But this authorizes any of those actions as well. Ratifies all of the other existing authority you've ever given them and yourselves, and then that's basically what it does. So,
Any other comments from anyone? I know Eric touched on some of the things he talked about the other night, and I know I had concerns, especially with some of the infrastructure improvements that the city is working through with Archie and whatnot, from what Deputy Mayor Williams told me prior to arriving here today. They're working through those, finishing up Stadium Car Park and Weiss Park and those things. I think actually they're meeting right now within the law department and IRG to get those things cleaned up, because they were concerned for a lot of folks getting these things finished and getting our parks back, being used by our kids. So those are my comments. Any other comments from any other board members? Hearing none, call the roll, Mr. Miller.
Mr. Ross?
Aye.
Mr. Dillard?
Aye.
Mr. Milligan?
Aye.
I vote aye. Mr. Rinaldi?
Aye.
It's 5 yeas, no nay.
3:41, and nothing further before the board. I will entertain a motion to adjourn.
So moved.
I'll second it, and all in favor for adjournment? Aye.
Aye.
Opposed, same sign. Thanks, everyone, for coming on a beautiful day.